Welcome everyone to our seventh and final housing hearing. This event tonight is going to focus on policy initiatives and potentials for moving forward. We have had 6 previous hearings. In those hearings, we've heard lots of powerful testimony. We've heard people discuss very difficult issues, from homelessness to housing insecurity to the problem of purchasing a home to the problem of being a landlord. We've gotten a really good idea of a lot of different stakeholders involved in the process of producing, maintaining, and possessing, living in houses in Kingston. So we're excited about tonight, looking forward to hearing some good ideas to think about what we can do to make sure that all of our residents, the residents who are here now in particular, will have adequate housing, safe housing, good housing going forward. There's a lot of ideas that have been percolating. This will help us, we hope, focus tonight. And then we'll be looking at a lot of possibilities. As you all know, there are currently 9 bills relating to tenant protections in front of the New York State Legislature. The legislature closes, I believe, on the 15th, unless they decide it's so much fun they stay a little longer. But we'll know more about what kind of tools we have at our disposal after the 15th, and so we see which of those bills get passed, if any. So with that said, we have 3 different presenters tonight. Justin Haynes of Legal Services of the Hudson Valley. He's going to go first. He will speak for a few minutes, and then if we have questions, we'll ask those of him. He needs to leave, so we will give him permission to go when he needs to. All right, and then after that, we'll have Joe Chaika, Guy Kemp, and Shane DeVita. Sorry, I'm thinking of the Inagata. It's the problem, you make the joke and you're my age and you remember the joke and not the, sorry. Okay, Shane. Shane DeVita. All right, and so they will speak as a panel, and then we'll have discussion after that. If there is time left over, we're scheduled here to go from 6:30 to 8:30. If there is time left over, anybody in the audience who wants to speak may have 3 minutes to speak on any issue of pertinence that is of interest to them. And we will stay here until 8:30, so long as people want to speak and people are staying for the event. When we do have the open speaking, 2 crucial things. One, there's no direct questioning of any of the members of the panel here. This is a common council hearing, so we're asking the questions during the testimony part. In the after part, so there's no direct questioning of the participants. There's also no direct questioning of other people in the audience, no direct response. Please direct all of your comments in that part of the session to the members of the Common Council so that we can get your ideas on the record and have a clear conversation afterward. All right, so with that said, welcome Justin. Tell us what we need to do.
Well, thank you so much to the chairman, the majority leader, and the Community Development Committee for holding this really important hearing. And I welcome the opportunity to testify before the City of Kingston's Common Council on behalf of Legal Services of the Hudson Valley at your request. I'll specifically speak to the state of evictions in the Mid-Hudson region and the impact of 2 pending bills in the New York State Legislature. The first being the EPTA expansion, which is Senate 5040 and Assembly 7046, and the Good Cause Eviction Bill, which is Senate 2892 and Assembly 5030, as the Council considers further resolutions and what to do in the future. So first I want to say I am a resident of Kingston. I live in Ward 9. My name is Justin Haynes, and I'm a supervising attorney at Legal Services of the Hudson Valley. We're the only provider of comprehensive civil legal services to all 7 counties of the lower and mid-Hudson Valley. Legal Services of the Hudson Valley provides free, high-quality counsel in civil matters where basic human rights are at stake for low-income individuals and families who cannot afford an attorney. Before I go any further, I also brought copies of my written testimony. If you'd like, I can distribute those. In 2018, we handled 15,285 cases directly serving over 12,000 clients and impacting more than 35,000 individuals. We serve clients in Westchester, Putnam, Rockland, Orange, Dutchess, Ulster, and Sullivan counties, And we have offices in White Plains, Mount Vernon, Yonkers, Peekskill, Poughkeepsie, Kingston, Newburgh, Goshen, Monticello, and Spring Valley. We've added some offices recently. As a practicing attorney for 15 years, both in New York City and the Mid-Hudson region, I am personally familiar with the pressures and concerns experienced by tenants in the current and developing housing market. As supervising attorney at Legal Services of the Hudson Valley, I oversee a team of 5 housing attorneys who provide counsel to tenants across the Hudson Valley each day, some specifically to the elderly or to veterans. In New York City and Nassau, Rockland, and Westchester counties, the Emergency Tenant Protection Act, or EPTA, the bedrock of the rent stabilization system, affords many tenants basic protections. The EPTA prohibits huge rent increases and allows tenancies to remain within families, providing tenants and their communities with security that they would not enjoy if subject to the forces of New York's overheated rental market. Yet tenants across the state who do not live in these areas are excluded from such protections, putting them at increased risk of displacement. The pervasiveness of month-to-month tenancies in the Mid-Hudson region leaves most tenants with no stability or protection. Here in Ulster and Dutchess counties, we are seeing the devastating impact of gentrification result in low vacancy rates, rising rents, and an unprecedented number of evictions in a legal system with few defenses for tenants. At Legal Services of the Hudson Valley, we see clients and their families in constant flux, having to move every 1 or 2 years and having to uproot their families from healthcare, schools, and jobs. Many times we define success in an eviction as getting the smallest judgment possible against our client, or getting 2 weeks to a month to move. Unlike in jurisdictions where tenants have protections, our attorneys assume the inevitability of eviction and instead focus our energies on limiting the collateral damage of the eviction. Even in cases here where tenants have meritorious defenses, central to our calculus about asserting the defense is the following realization. Even if we successfully assert this defense or this case is dismissed, because the tenant is month to month and not entitled to a renewal, how soon will the landlord be able to evict in a subsequent no defense holdover? Recent local efforts reflect a growing recognition of this lack of protection for our tenants, such as when the Kingston Common Council voted to adopt a resolution calling on state lawmakers in Albany to eliminate the geographic restrictions from EPTA, allowing cities like Kingston to adopt rent stabilization protections. However, while extending EPTA protections represents a necessary first step in providing such much-needed protections for tenants in Ulster County, unlike in the densely populated lower counties, these protections would not impact the majority of renters in our Mid-Hudson region because they only apply to tenants in buildings with 6 or more units. In Assembly District 103, 66% of rental units are in buildings with 1 to 4 units, meaning that 2/3 of tenants would not be included under the EPTA, even if adopted locally. In Kingston alone, of the 4,700 apartments with no protections against price increases or unfair evictions, only 1,250 units would be covered by EPTA. This leaves tenants in nearly 3,500 units subject to huge rent increases with no long-term tenancy rights. The Good Cause Evictions Bill could have a greater effect on local tenants and close the justice gap. All tenants across New York State need the tools to effectively stand up for their rights to safe and secure apartments. As to the state of affordable housing, each day more tenants across the Hudson Valley are facing the potential loss of their homes due to ever-increasing rents that exceed most of our clients' ability to pay. As new luxury developments move into Kingston and other cities across the Hudson Valley, tenants are increasingly struggling to make their rents. These effects are exacerbated by the profusion of Airbnb and other high-cost, short-term rentals which continue to constrain the supply of available housing, especially for lower-income populations. Across New York State, Assembly District 103, which comprises parts of Ulster and Dutchess counties, rental units make up nearly 1/4 of the housing stock. In Kingston specifically, there are nearly 6,000 rental units, 4,700 of which have no protections against rent increases or unfair evictions. All housing indicators, including rent cost, vacancy rates, rent burden rates, and eviction rates all point to a deepening housing crisis. According to Ulster County's annual Housing Affordability Survey, average rents across the county have risen on average 53% since 2004, far outpacing increases in wages. Furthermore, the 2018 vacancy rate was 3.16%, far below the generally accepted healthy range for vacancy rates, which is at least 5%. Currently, about 55% of Ulster County renters are rent burdened, and about 30% are severely rent burdened. These renters are unable to support large increases in rent and are vulnerable to eviction by landlords seeking to profit from rapid gentrification. The combination of skyrocketing rents and few available units further concentrated power in the hands of landlords and limited the options of these low-income tenants. The scarcity of affordable housing stock across the county has directly contributed to an increase in evictions and homelessness. According to one study, the number of evictions in Ulster County rose by 57% between 2013 and 2019. In 2018, there were 676 evictions across the county, an all-time high. RUPCO has closed the waiting list for Section 8 housing and reports that local motels have filled with people in need of housing. According to the annual point-in-time count, in January 2018, there were 444 homeless individuals across the county, compared with 320 in just 2016. The severity of the current housing crisis makes it all the more critical that we institute adequate protections to allow these families to remain in their homes. Which brings me to the Good Cause Eviction Bill. The Good Cause Eviction Bill would extend critical right to a renewal lease and add protections from unconscionable rent increases to all tenants across New York State, except those living in owner-occupied buildings with 4 or fewer units. The bill requires a landlord to obtain an order from a judge certifying that an eviction is for good cause before they can remove a tenant from the unit. It further stipulates that arriving at the end of the lease alone is not good cause. The bill also acknowledges that steep rent increases are often de facto evictions and requires that rent increases of more than 1.5 times the annual percentage change in consumer price index be presumed unconscionable unless accompanied by special circumstances. This bill would represent a huge step forward for my clients across the Mid-Hudson Valley. If this bill were passed, approximately 3,000 Kingston families would gain additional protections. For legal services attorneys on the front lines of this housing crisis, these protections would help even the playing field in court, reducing the number of eviction proceedings brought against low-income tenants and empowering them with many of the legal defenses tenants in other parts of the state already enjoy. The Good Cause Eviction Bill would address some specific problems that we frequently encounter, of which you may be unaware. Frequently, impending evictions result in tenants having to move precipitously. The evicted tenant then does not have the luxury of extensively shopping around for the best maintained apartment. They often are looking for anything that is available and affordable. As a result, our tenants often live in a substandard housing. These tenants' housing choices are further limited by widespread tenant screening that refuses tenants based on having previously been involved in landlord-tenant matter, a history of money judgments, or overall credit score. If the tenant seeks to move with a rent subsidy from DSS or Section 8, they still face blatant refusals by landlords to accept those sources of income, despite this type of discrimination being recently outlawed last month. Many tenants, when still in their apartments, cannot raise a warranty of habitability claim affirmatively, as our justice courts are not set up for tenants to sue their landlords for repairs. Instead, tenants must withhold their rent, inviting a non-payment action against them, where they can raise the landlord's failure to make repairs. However, if a tenant is month-to-month, the vulnerability that creates prevents them from raising this defense, because even if the landlord repairs the apartment, the landlord can evict the month-to-month tenant for no reason the following month. In the Mid-Hudson Valley, a number of judges are landlords themselves and lack any sympathy for a tenant living with a mold condition, a lack of heat, or plumbing problems. With good cause eviction requirement, tenants could assert the need for repairs without fear of another retaliatory eviction the following month. In addition, Section 8 voucher tenants in evictions face unique pressures. We see many Section 8 tenants facing eviction after only a year in their apartment when a landlord chooses not to renew the lease. Tenants with Section 8 vouchers face these simultaneous obstacles, including they have trouble finding landlords willing to take their subsidy, the rent to be paid must be within the payment standards of the Section 8 program, and the apartment must be in good enough condition to pass the inspection from Section 8, all within the short time frame that HUD allows for a tenant to move while preserving their voucher. These tenants are looking for new housing in an incredibly competitive market and must overcome many hurdles. Many non-payment evictions are de facto holdovers. A non-payment case can be brought after a 3-day notice. A holdover for a month-to-month tenant must be brought after a 30-day notice. Many landlords bring non-payment actions against tenants that they want to evict, even if they owe a trivial amount, because the short wait time, but then go on to essentially treat the case as a holdover where the tenant gives up possession as the goal. Our frequent advice is, even if you pay these arrears now, as claimed by the landlord, your landlord doesn't like you and clearly has stated that they will evict you next month in a holdover. Many charities in our area, as well as DSS, are aware of this lack of ability to remain and often want to see a lease of 6 months or more before they can help pay rental arrears and a non-payment. Reasonably, the charities and DSS don't want to sink money into a losing proposition. But if there was good cause requirement that gives tenants a right to a renewal, this would assuage many sources of rental arrears assistance that the tenant can remain in their apartment upon payment of the arrears. While numbers and statistics tell us the massive scale of this problem, it's the specific stories of our clients who have lost their homes that demonstrate its impact and the impact that the good cause eviction bill would have in reversing this trend. Along those lines, I'd like to share the stories of a few of our clients whose options would have been notably different had this bill been enacted when they faced eviction. For example, Miss S is 68 years old, lives in Kingston, and does not have any immediate family. Previous to living in this apartment, the client had broken her hip and was in the hospital and then a rehab facility. The problem was that she could not leave the rehab facility because she had no one to help her and no place to go upon discharge. She's confined to a wheelchair and needed a health aid in place. Above all else, she needed a wheelchair-accessible apartment. She received a special subsidy for disabled people and this allowed her to move into a private apartment with a large Kingston landlord. Her new apartment was wheelchair accessible. In her first year in the apartment, she asked them to make repairs on several occasions. After a new property manager took over in her second year of the apartment, she began to have problems. On one occasion, she went out for a cigarette late at night and could not get back into her home on her own. Unfortunately, it was 3 a.m. and another tenant had to help her back in, but this then got reported to the building manager. She's also been accused of having her TV volume up too high. Approaching the end of her third year in the apartment, her landlord decided not to renew her lease, and she has been unable to find another wheelchair-accessible apartment. If she is evicted, she will lose not only her home, but her subsidy completely, and she could get stuck in a homeless shelter indefinitely. In another case, which we'll call M, is a 61-year-old single female. She works and goes to school and is not home a lot as a result of her busy schedule. She's quiet. She's lived with her 2 cats since she moved in 4 years ago. However, 2 years ago, a new company out of NYC bought her building and made her fill out an application. On it, she disclosed that she had 2 cats. She had never had a lease until the summer of 2018, when she signed the first lease for this apartment she'd been living in for 3 years. Unbeknownst to her, her lease had a provision excluding pets. Additionally, the front of the lease was marked as $0 next to pet fees. She always paid her rent on time before the 5th of the month, when her landlord would then charge a late fee. Suddenly, in December 2018, she was charged $1,200 for 2 years retroactive pet fees at $25 per cat per month. She was also charged a $600 one-time pet deposit fee. Suddenly, in addition to her rent, she now owed $1,800 in retroactive fees, plus an ongoing monthly pet charge of $50 a month. She refused to pay these pet fees because her lease was marked $0 pet fee, and she had already disclosed the presence of her cats in her application. Over several subsequent months, she continued to pay her rent on time. In 1 month, her landlord lost her check, but didn't tell her until after the 6th of the month when a late charge was assessed against her. She replaced the check by the 8th, but the landlord never removed the late fee. After 6 months of refusing to pay the pet and late fees, her landlord then sued her in non-payment of rent and made it look like the pet and late fees were recently unpaid rent. After negotiating with the landlord agreed to waive the pet fees that had accrued as long as she agreed to pay the $50 monthly fee going forward, even though it's not in her lease, and that she had to also agree to pay the accrued late fees of over $300. When she asked why she should pay, the landlord said if she didn't accept the offer, they would bring a holdover based on violating the no pet portion of her lease. If that were not successful, they would wait 2 months until the lease was over and not renew her lease, then bring a no defense holdover. The client capitulated and paid the late and pet fees going forward because she didn't want to face a non-renewal. This kind of wrongful strong-arming by a landlord based on exorbitant, bogus fees would not be possible if the good cause bill were enacted. Miss H is a 26-year-old single mother of a 7-year-old autistic son. She lived in an apartment with a large, well-known landlord that owns multiple complexes in Kingston. This apartment was affordable because the building was in the Low-Income Housing Tax Credit, or LIHTC program. She had found out that in mid-March, her lease was not going to be renewed. Her lease was up on April 30th, and unbeknownst to her, under LIHTC, she should receive a renewal lease unless the landlord has good cause to evict her. When she spoke to the building manager, she was told to attend a meeting with the landlord's attorney. When the tenant arrived at the meeting prior to any court case being filed, she found the property manager and an unofficial security guard at the property who presented her with several quote-unquote legal documents and threatened her that if she didn't sign them, she and her son would be out on the street immediately. She ended up signing the documents admitting to numerous lease violations that never occurred and agreeing to be out of the apartment much earlier than law or her lease required, as well as a confession of judgment, which essentially precluded her from raising any defense in a court action, and consenting to give the landlord possession of the apartment. She signed without knowledge that she was entitled to a lease renewal. The tenant wanted to stay until August 31st, but the landlord would not let her. She tried to understand why this was happening. She learned that the reason for her termination was rooted in a one-time incident where she had called the police to report the theft from her apartment. That same theft had also resulted in her being late with her rent payment, a one-time incident. After much begging, the landlord gave her an extension until June 30th. The client wanted at all costs to avoid having an eviction judgment on her record because it would mean that she would not be able to rent anywhere again in Ulster County because of the prevalence of tenant screening and the Ulster County Eviction Registry. However, court was unavoidable. Only with our assistance was she able to legally void the confession of judgment she had been pressured into signing, and only because she lived in LIHTC housing with a good cause eviction requirement were we able to get her several months' time through litigation and settlement to find suitable alternative housing. The good cause eviction bill won't extend the good cause eviction protection to all tenants. Would extend the good cause eviction protections to all tenants, not just the ones in LIHTC housing. If we hadn't had this tool and assisted her, she and her autistic son would have been evicted without adequate time to find suitable housing. And lastly, one last case. Mr. C is a 66-year-old, and he lives alone in private housing with 4 units. The home is solely a rental property for the owner. The tenant had lived there for 11 years, paying $650 for his rent. After a dispute with the owner in which Mr. C accused the landlord of stealing some property, which happened to be some manure and some earth, and then filed a police report, the tenant received a 30-day notice to quit, the predicate notice to a holdover. Then the landlord brought the holdover. While we were investigating his defenses, he informed us that when the landlord stole his property, the landlord had also called him a sick fag and threatened him. After we assisted him in filing a complaint with the Human Rights Commission and a motion to dismiss in court, the landlord withdrew the case. However, within a month, they served a new notice to quit, and then later a new holdover. We again moved to dismiss, and the Human Rights Commission also got involved in negotiating a conciliation settlement. This went on for several months without resolution. Finally, the landlord then sent him a notice increasing the rent from $670 to $1,195, plus an additional $495 for rental of the garage space that had previously been included in his rent. Overnight, his rent more than doubled in retaliation for the tenant attempting to live free from theft and discrimination. The tenant was forced to move. If the good cause eviction bill had been law, this tenant would have been able to assert in court that the rent increase was unconscionable and beyond the percentage allowed by law. He could have vindicated his right to live free from harm and harassment. I hope these cases have illustrated the many injustices our clients face as vulnerable tenants and how their lives would be improved by proposed legislation. Thank you for the opportunity to testify before the Common Council Committee. She's one of us. Yeah.
All right. Thank you very much, Justin. One question is, could you explain to us what a holdover is?
So really, there's 2 types of eviction proceedings. One is a non-payment proceeding, where essentially if the amount claimed in back rent, or sometimes what happens is a lease will have a clause that includes any late or legal fees as added rent. As long as those amounts are paid, then the person can remain in their apartment, subject to their lease or their tenancy. A holdover, by comparison, is an action where it's not really about the money. It's about recovery of ending the tenancy and recovering the possession of the apartment for the landlord.
And so when you were speaking about judges, you made it sound as if judges are predisposed to side with landlords because of A, their own involvement in property ownership, but B, the way the laws tend to be organized toward the benefit of the landlords. So I'm wondering, in terms of judges, is there something that you could recommend to us that would help them to perhaps, even if the laws didn't change, are there ways that we could help them see their cases in a different light?
Good question. Like I had mentioned in my testimony, I did practice in the city for a number of years before moving to Kingston. And at least there, because there's a number of tenant attorneys who then become judges, it seems more balanced, that there's sort of an equal playing field for both tenants and landlords. One of the problems that we've had over time is that defenses that tenants had in a holdover, for example, if the basic concept is that the landlord has ended the tenancy and set out a date by which the tenancy ends in a notice to quit, if they accept rent after that time period, then it's, the law had originally said that there was a waiver of that termination of tenancy. And oftentimes landlords made that mistake and renewed a new month-to-month tenancy by accepting rent from a tenant after a period which they should accept no rent. I hope that is clear. Over time, the law has eroded to the point where you have to show a much more meaningful acceptance of rent, that there has to be a lot more intention shown. So just accepting a check from DSS that might have been electronically sent or a payment from Section 8 no longer will by itself constitute a waiver. So we've seen an erosion of the law in terms of providing defenses for tenants.
That's at
I've
the
mentioned
state
many.
level?
What's that?
That erosion is at the state level, the county level?
It's in the particular judicial department that we're in,
Okay.
but our courts contribute to that. Additionally, what was I going to say? I lost my thought. I don't know, but I will say in my experience, and our offices cover wide geographical areas, which are made up of a lot of justice courts. And in a justice court, you do not have to be an attorney in order to be the judge. You just have to be elected by your community. I think there are other states that have other systems by which there are committees or commissions that appoint judges. They aren't just directly elected. There could be more requirement that courts, that judges have to be attorneys. There could also be we have other problems that we routinely see. Although courts are mandated to have translation services, we find that many courts, justice courts, are ill-equipped to handle anyone who speaks a language other than English. And we've had anecdotal experiences where the courts have required the tenant to bring somebody who's going to translate for them, contravening federal law and state law. Additionally, when someone's facing an eviction and say they may not have shown up in court, they missed the court date for some reason, the landlord gets an automatic judgment against them, a default judgment. And what happens often is if a tenant then wants to try and halt that eviction and then assert no, I really had defenses to this, there's a reason why I missed this, that requires a motion called an order to show cause. By comparison, in the city, those forms for an order to show cause are readily available in every court in every jurisdiction. Here, courts do not stock order to show cause forms anywhere. They rely on legal services of the Hudson Valley to provide tenants with the forms necessary to stop an eviction. And that seems fundamentally unfair. We can't be responsible. We're not open all the time. We're not available all the time to give somebody this form. These forms should be stocked by each and every court. So I've yet to encounter what I would deem a tenant-friendly judge. who's predisposed to find and believe tenants upon most appearances. But there's just so many things stacked against tenants between the law, the lack of resources, the lack of understanding, and the disposition of the courts. And the fact that, let me just add this, so few tenants are represented. You know, in both our Kingston and Dutchess offices, we have 2 dedicated housing attorneys for a whole county. We have other attorneys who have general practices like elder law or veteran who might pitch in and do some housing cases. But it's a paltry resource when considering how many evictions are happening in each county every year. So that's just another element that most tenants are unrepresented when facing these things. The other thing I was surprised by when I moved here was that it's a struggle even for a tenant to request an adjournment to get an attorney, to speak with an attorney. Frequently, the court will give them a hard time, they may deny them, or if they do grant it, they'll say, upon return, your case is set for trial, which is, you know, unconscionable. It's like how, you know, given all the factors that we have a tiny resource, a lot of people coming through the pipeline, the fact that the next court appearance is going to require a trial, I mean, is also setting things up against a tenant.
Yeah, if I could go back to the example you gave where the money, they then accepted the money. Did something change in the law that prevented that from, maybe I didn't understand it clear. I got the impression that if they accepted the money, then that would basically, if they wanted to start the process, it would have to start over, the clock would have to start again. I'm not sure if that's correct, but what changed, if that is the case, and what changed that isn't the case anymore?
Let's say before the defense was bulletproof, there was no question, any acceptance of rent would nullify that termination of tenancy.
And they would have to, so that would start the
yes,
clock, and then they have to start over.
It would stop